That is not accurate. On a state level, there is no more eviction moratorium. Thanks everyone for coming on today. What I wanted to do was do a quick review on what's going on what we talked about last month. Statutorily, there really weren't a whole heck of a lot of changes in the last month, but there were some changes that happened with the litigations going on against the county and the city of Los Angeles. So I just wanted to bring you up to speed there. I will warn you, there's not a lot of good news, but it is news and I am obligated to report on it. So real quick, we'll just cover that. The first thing is that, let's just review where we're at. We have two pending cases, one against the city of Los Angeles by AGLA, it's the Apartment Association of Greater Los Angeles, and then one by the Apartment Owners Association against the county. The AGLA is a very old case. It was filed back in June of 2020 at the beginning of the moratorium, at the beginning of COVID, I should say. And it's essentially kind of dead right now. Reason being that it went up to the Supreme Court and they did some briefing. The Supreme Court even asked for additional briefing, asked for a response from the city, which it usually doesn't do unless it's very interested in hearing a case. But then, unfortunately, they decided not to grant certiorari, which basically means that they did not agree to hear the case. Once that happens, essentially whatever the Ninth Circuit ruled becomes the law. And the Ninth Circuit ruled against AGLA. So for right now, the city moratorium remains in place, which is very unfortunate because I was very optimistic and very hopeful that the Supreme Court would take the case, and given their prior rulings and their political makeup, we would have a far greater chance of getting a good result than we had with the district court or the Court of Appeal, both of whom who ruled relative to now a lot closer to the beginning of the pandemic and the middle of the pandemic when it was raging and everyone was sick and the hospitals were filled. And so I think that was a lot of the reasoning and a lot of the impetus behind the negative rulings. And now that we're beyond a lot of the emergency, the actual real emergency timeline, I was hoping the Supreme Court would take it and give all of the Los Angeles landlords some relief, but it didn't happen. So basically, we're now waiting to see when the city council and whoever the mayor is going to be under sufficient pressure to basically remove the emergency themselves. Now, there is some movement in the city council to start at least preparing reports to talk about removing the emergency or amending the emergency, amending the eviction moratorium. And so I think they're starting to feel the pressure. When that's going to happen, we really don't know. That's unfortunately the answer. In terms of the county lawsuit, the county filed in, the Apartment Owners Association filed in LA County against the county of Los Angeles, essentially for the same kind of reasons, basically saying that the eviction moratorium extension was unnecessary and unlawful, given the all the inroads that have been made towards fighting COVID, fighting unemployment, and the fact that there's really no emergency basis and no need for the moratorium. And so they were going to have a hearing on a preliminary injunction to enjoin the county from enforcing their moratorium extension. And right before that happened, the county removed the case. Remove means that they transferred it from the state court to the federal court. And this is problematic for a number of reasons. Number one, it canceled the injunction motion. So we didn't even get to get a ruling on the injunction motion. And two, they transferred it to the federal court and ended up with a judge that is more on the liberal side. And a judge that's more on the liberal side is more likely to enforce and allow the county to enforce their eviction moratorium than a conservative judge would be. So this is not a statement on the pros and cons of liberal or conservatism. It's just saying that each of these judges, federal judges, tend to be political appointees. More or less, you can kind of decipher it from which president appointed them. So your Carter, there are some judges who are Carter appointees. Your Carter, Clinton, Obama, Biden appointees tend to be liberal judges, and your Bush, Trump appointees and Reagan appointees tend to be more conservative judges, and those judges would be more sympathetic to the landlord business owners versus the liberal ones being more sympathetic to the tenants and the government. So unfortunately for landlords, we landed on an Obama appointee. So it's problematic. So that's going to be an extra hurdle for them. And then once they get to the Ninth Circuit, same hurdle that we had with the Agler case. So once again, we're in a situation where the only way to really get these moratoria to come off is by pressuring the local politicians. Some of them are already starting to turn a little bit. Even when they extended the county moratorium, 1 out of the 5 board members, the board of supervisors, voted against it, which is great, 20% of the way there. But you would need to get another 2 to vote to amend the moratorium. And once you give something to the people, it's very hard to take it away. Now, just so we stop there, does anybody have any questions about that particular issue? Litigation issue? Probably not. Okay, fine. Let's do a real quick recap of what we talked about last time with what the change was, in case anyone was not on that not on that webinar, didn't catch it on the YouTube. So basically, the last state change we had, which was fairly positive, is AB 2179. And it's important to remember what it does not do. And there have been people who reported on this on the media, online. I've had so many questions. And people keep telling me, oh, didn't they extend the state eviction moratorium? No. The eviction moratorium on the state level, which is what we're talking about with AB Assembly Bill 2179, was over back in September. There has not been an extension of that eviction moratorium, either by this law or even the one that came before it. So that is not accurate. On a state level, there is no more eviction moratorium. It also did not give more time for applications for the emergency rent relief. Okay, that's commonly known as ERAP, Emergency Rent Application Program, Rent Assistance Program. That closed. So last time we had the webinar was March 30th. March 31st was the last day for any tenant or landlord to apply for rent relief from the state. If you didn't have your application in by the 31st, there are no more applications. If you go on the Housing is Key website right now and try and apply, you will see there is no more applications for rent relief, and there's no indication, at least that we're aware of today, that the state is going to reopen or reoffer more money. There are certain city and county programs that are still open, right? But it's very city and county dependent. So the city of LA doesn't have one. The county of LA doesn't really have one. Some of them are talking about it. Some of them still have it. Some of them are very limited, like they can only give you a couple $1,000s. But there are hundreds of cities and more than 50 counties in California. So it's you have to go property by property, city or county by city and county, to determine if your specific area still has a rent relief open. But generally speaking, it is closed. Now, if you had an application in by the 31st, what this law did do is extend the time for that application to get processed. And while an application is processed, as you probably know, you can't evict the tenant. So if someone didn't pay rent before April 1, and the application that they have is still open, and they are still processing the applications that were timely received. So if you have an application that is still open and you have served them a 3-day notice or potentially even a 15-day notice if it's from before September 30th, and your 3 or 15-day notice demands rent that is part of the application that is still pending, you still cannot evict that person at least until July 1, right? That was really the crux of what this AB 2179 did, right? What it also did, which is very helpful, is it increased the time that the state law preempts the local law in terms of them being able to change their own local moratoria. And this is important because as it affects LA County, it's quite vital. What happened with the county was that they, at the end of January, extended their moratorium. And this was the big news because they essentially extended it till the end of the year. But they admitted, they said, well, we're preempted from state law from reapplying a defense to non-payment of rent evictions due to COVID circumstances. That specific issue, they were preempted from reapplying that to the LA County residents because of the state law preemption. That state law preemption ended on March 31st under the old state law. And so what they did at the end of January is say, okay, fine, we'll wait till April 1, but starting April 1, we're going to give everyone in the county back this defense they had before September 30th, the first time it expired. And they were not able to re-put it back or not able to extend it. This new law, AB 2179, came out and said, no, we're moving the preemption date from March 31 till June 30th. So now the defense that was supposed to have come in 27 days ago for LA County residents never came in because the preemption date moved. Now, the good thing about the LA County extension was that it was only good for everybody in the county until June 30th. Sorry, until May 30th. And by its own terms, starting June 1, it was only applicable to families making less than 80% of the AMI, the average median income. Starting June 1st, by its own terms, that COVID defense would be limited to people who are low income. Well, now, since they can't even bring it back until July 1, by the time July 1 rolls around, unless they change things, but as it's written right now, the only people who will get back the COVID defense are people who are making less than 80% of the average median income. As we've also discussed a number of times, the local LA County moratorium does provide for what's called self-certification, both of COVID status. That doesn't mean they have COVID. It means that they have a financial COVID-related circumstance and low income. And if you've been following the webinars, you know that technically speaking, that is an illegal provision because the United States Supreme Court had ruled in a New York case that having self-certification means you are a judge in your own case, which is not allowed. It says it violates the long-standing teaching of the United States Supreme Court that a person cannot be a judge in their own case, which is exactly what it is when you self-certify. You are basically coming and saying, I'm only allowed to avail myself of this defense if I have a COVID-related circumstance, or if I am low income. I am self-certifying both of those things without having to provide any evidence. Well, that means you're the judge, and you're also one of the litigants. That's not allowed. So some of the judges in LA County are understanding that this is an illegal provision and setting hearings where the tenant will have to come and prove some sort of COVID-related circumstance. And starting July 1st, they will have to also prove their low income status. And if they don't, they are not going to get their defense. As it stands right now, though, if you are outside of the city of Los Angeles, but in LA County, between now and July 1, there is still no COVID defense to a non-payment of rent eviction. So now is a prime time to try and start those evictions if you have property that's in those jurisdictions that I just discussed. If your property is within the city of Los Angeles, there we still have the COVID defense because their moratorium is from May of 2020, was never changed, and therefore was never preempted by the changes in the state law. So unfortunately, in the city of LA, it's a little harder. Again, they also have self-certification. It also suffers from the same problem that it violates the United States Supreme Court ruling. And again, some of the judges say, nope, that only applies to New York, and will allow a very simple proof or maybe even no proof. And some judges will say, no, let's have a hearing about it, and I'll make the decision as to whether the person can avail themselves of the COVID defense. Remember, in the city of LA, there has never been, and there still is no income requirement. So the defense applies to anybody who has a COVID-related circumstance which prevents them from paying rent. Now, I think one of the reasons the judges are starting to ask the tenants to prove this is because they know full well there virtually are no more COVID-related defenses. We are now past 2 years since the pandemic began. Unemployment in the county is almost to what it was before COVID started. So if you want a job, especially in the city and the county, for the most part, you can have one or two or three, and the employers would be happy to have you and will overpay for you. So even judges are now understanding, you know what, this is probably tenants taking advantage of the system. And unfortunately, there are a lot of tenants like that. So as a lot of you who are on this on this webinar, who are my existing clients know, we are actively going after tenants who are taking advantage of the system and are not going to be able to prove their case. There's no 100% guarantee that it always works, but we are, I think, maybe one of the few law firms that are really actively going after all these tenants who are trying to take advantage of the system in a way that's unlawful and unethical. So that is what's going on with the residential side. Really quick to talk about what's on the commercial side. And I know not all of you have commercial property, but some of you do, or you know people who do. I consistently hear misinformation about the status of the commercial evictions. So I must repeat, there is no more commercial eviction moratorium in California. I understand that the city of LA still has one as part of their May 2020 moratorium, but I'll try and make this part of the lecture short. There's a state law that says you cannot have local restrictions on commercial leasing or evictions. That law was suspended for a time by the governor, who had the right to suspend it until September 30th of 2021. And then he ended that suspension. Once you end the suspension, the law comes back, the state law preempts the local law, and numerous of the local entities straight out admitted on their websites, we are now preempted, we are prevented. It is illegal for us to continue any sort of eviction moratorium for commercial spaces. We're not allowed anymore. The governor has put back the restrictions. Only the city stayed silent when that happened. They didn't say, oh, well, it's over or it's not. The county extended it illegally, knowing full well there's nothing anybody could do about it for 3-4 months. They're right about. And then at the end of January, they also came out and said, oh, there's a quote unquote new law. We are now preempted. And if you look in the LA County moratorium extension that they did at the end of January, it says in big, bold, capital, underlined letters, there is no more commercial eviction moratorium. Right? So it doesn't exist. Even in the city where it's still technically on the books, it is also preempted. If it's preempted in the county, it's preempted in the city, right? That doesn't always work. I'm not saying that as a general rule, but in this particular case, it is. So if you have commercial tenants who are not paying their rent, you can evict them now. You absolutely can do that. There are certain restrictions on when they have to pay you back the rent, and that all depends on your definition of when the moratorium ended, either at the end of September or at the end of January. But one way or another, they do have to pay you back the rent. And so under certain circumstances, you can also sue them to get the money that you didn't get paid, whether they're there or not. So we have cases against commercial tenants that we're actively pursuing in civil court. We have UDs that we're actively pursuing against evictions, that we're actively pursuing against non-paying commercial tenants. It is open season for commercial evictions. So if you need help on that, we're going to put all of our contact information in the chat. you can do that. And if some lawyer or someone else tells you that no, you're still not allowed to, send them to me. And I will happily educate them. Or better yet, just don't call them and call me. So that's what's going on the commercial side. Now, let's stop for a second. And now that we've covered that territory, does anybody have any questions so far about the stuff that we discussed? Feel free, raise your hand. You can write it in the chat. You can unmute yourself and just ask the question. Anybody got anything? No? Nothing? Okay. Okay, so one point of clarification that I just wanted to make in terms of how 3-day notices work nowadays. So last time we talked about the fact that they added some language to the 3-day notices that you have to put. I want to clarify now that that additional language, which basically said that you have to tell the tenant that they may have certain protections from eviction if they have an application pending that they submitted before March 31st, is only if you are doing a notice after April 1, but it pertains to rent that became due before April 1. If you are doing a brand new notice starting April 1, only for the rent that became due after April 1, April, May, June, et cetera, you actually don't even need this special little notice. If you have it in there, it's totally fine. It doesn't change anything. But if you don't have it in there, it is also fine. So just want to clarify again that that new language applies to post-April notices for pre-April rent. If you are doing, again, other kind of notices, you're allowed to go back a year for AUD, right? So if you're doing notices that are before September 30th, remember, you might still have to do a 15-day notice. And so depending on when your rent is due, you may have 1 or 2 or 3 different notices that you have to put out. So keep that in mind. And again, if you're confused about which one to use or which one to do, feel free to just give us a shout and we'll be happy to help. Okay, so essentially that covers most of what's changed. As I said, oh, we have a question. Okay, so buddy, I had 2 tenants tell me that Housing Key told them they still only had to pay 40% in April while their application was being processed for the period ending March 31st. Unless that's a local city rule that I've never heard of, Housing is Key basically says a lot of different things. There's never been a 40% rule. That doesn't really exist. Remember, Housing is Key is a state website. So in order for Housing is Key to be able to tell people that there's some sort of a state, LA City, no. So with LA City, they can pay nothing. And if they have a COVID reason, then they're theoretically protected from eviction. But there's no more 25% threshold. There's no more 40% threshold. This is another question I get a lot. What if they paid only 25% of the rent in April? Are they protected? No. The whole 25% thing ended September 30th, 2021. For anyone who was not recalling, basically what happened was if a tenant paid all the rent from, I'm sorry, not all, 25% of the rent that became due from September 1, 2020 through September 30th of 2021, that's a 13-month period, then they could not be evicted for not paying the other 75%, right? And it's just, you do it on a full 13-month basis. So for example, let's say somebody had paid 4 months in a row in full, September 2020, and then October, November, December. That's 4 months out of 13, right? That's more than 25%. And then they just never paid again in 2021. Nothing, not a dime. January to September, not a dime. They would still be protected. We could not evict that person due to the non-payment through September 30th of 2021. However, that does not apply to their non-payment starting in October 1, right? They did still have to start paying the rent in October 1 if they didn't pay, Again, if you're in the city or the county, you might have had a COVID reason if you could prove it, at least in the cases that we filed. But there was no more ability to pay 20% or 40% and then be spared from eviction. That's not really right. Now, I will tell you that we've heard a lot of interesting things from Housing is Key. For example, we had one of the administrators admit to us that they were purposefully not denying claims in order to keep them pending, because while they are pending, at least for the months for which they are pending, you could not evict. And you couldn't even continue with, you couldn't even file, get a summons from the county. So therefore, as long as they just keep it pending, even if they're going to end up denying it, they are saving the tenant from eviction without even having to spend a dime. So they figured this out very quickly, and we've had them admit it, but they're doing that on purpose, which means they're either going rogue or they've been directed to do it. In either case, unlawful, but not much we can do about it. We've had situations where they approve them for $0, thinking that, well, if it's an approval, they can't use it as a denial, because in order to file an eviction based on a denial from ERAP, you have to actually produce some sort of evidence of a denial, either a letter, an email, a screenshot, something. So they're thinking, oh, if I just give them an approval, even if it's for $0, the judge won't think of it as a denial. That doesn't work, but they thought it did, and I've seen it. So that's the situation with the ERAP. There's no 40% rule that I've at least ever heard of. Okay, so we got another question from Katie. Santa Monica, a tenant applied for rent relief but has not paid a few months after the pandemic either. Can we start the eviction process? So Katie, when you say hasn't paid a few months after the pandemic, what do you mean? They haven't paid a few months since when? Like since April? You can either unmute yourself or, after, as in since April. Yes. So in Santa Monica, that's a separate city. It's still within the county, but it's not an LA city. So if they have not paid starting April, you can start an eviction now. All right. Are tenants in single-family homes allowed to be given a notice to move if they owe any rent from March to June? Or will landlords still convert outstanding rent to civil debt? Okay, so the single-family home tenants are essentially treated as the same as the apartment and multifamily tenants. If they owe rent, yeah, you can start the eviction. Again, if they're in the city, they may have a defense. If they're low income in July and outside the city, but in the county, LA County, they may end up having a defense. But otherwise, yes, you can go ahead and file evictions on them for non-payment of rent. There's no conversion to the civil debt. That whole scheme ended on September 30th. And that's the whole thing that we were just talking about, where they paid 25% for those 13 months. If they did that, then the other 75% was converted to civil debt. It's the same story from the March 1 till August 31, 2020 debt. So we're going back 2 years now, but that was converted to civil debt automatically. They didn't have to pay anything. That 4 months was just March, April, May, June, July. 6 months was converted to civil debt as a matter of law. Then September to September, they had to pay the 25% to get that benefit. And now that doesn't exist anymore. So there is a civil debt that you can go ahead and sue them civilly, but you can also file AUD. And you can do both if you want to. We use that tactic a great deal in order to provide additional pressure. I will comment on one thing that, remember, the small claims issue is getting harder and harder to use. What the state law did was they said, all right, we're going to make it easy or easier for landlords to collect the unpaid rent. We are going to uncap the small claims limits if you are collecting COVID-19 rental debt. And they define that as rent that became due between March of 2020 and September 30th of 2021. So if you happen to be renting to some, actor who decided not to pay, and he's paying you $100,000 a month for some fancy mansion, and he didn't pay for that whole time. Now he owes you more than $1 million worth of rent. You could technically go to small claims court and sue him for more than $1 million in rent, even in small claims, with no lawyer. So there is no cap. On top of which, if you have more than 2 of these cases, usually small claims laws would not prevent you from filing. But now you can file as many of them as you want, so long as what you are going after is that rent that became due between March 20 and September 21. However, if now you have rent that became due after that time, October 1, or before that time, so February 20 and going back, then the regular small claims rules apply to you, which are if you, the plaintiff, the owner, are an individual, 10K max. If you are an entity, LLC, LLP, general partnership, corporation, then it's 5K max. And you can only file 2 in any 12-month period, right? So how do you get that money to file a regular civil claim? For that, if you are an entity, you do need an attorney. You cannot legally go as an entity and represent yourself in a civil claim, even if you want to, a regular civil non-small claims case. If you are an individual, technically you can, but it's a very bad idea because the rules are designed for lawyers to follow and to have to try and navigate, whereas small claims is really designed for anybody to be able to go and do. So now that we are in April of 2022, a lot of the rent that's become due is either a mix of pre-September 21 and after, or it's just after that. So you're going to have to either go to small claims and waive the rest, which you can do, that's your right, or you can file a civil claim. We also help with that if you need. So, Buddy asked, can tenants still claim COVID in April until when? So Buddy, just a real quick recap. In the city of LA, yes, they can claim COVID. Until when, we don't know. The city council is the one that is going to have to fix that and amend their moratorium. There's no indication of when or if they're going to do that. Outside of the city of LA, it would in the county. No, they cannot claim it now. They might be able to start claiming it in July if they are low income, meaning they make less, the household makes less than 80% of the average median income. So Benko is saying, if the tenant has COVID issues in a single family, they're protected until June 30th. No. So again, single family apartment doesn't matter. Same answer we just gave. If you're in the Benko, I'm sorry if that's not your name, but that's just what it says here on the screen. Where's your property? Where's your single family home? Nope. Well, let's just assume it's in the city of LA. In the city of LA, they can claim COVID for as long as they want. We don't know when that's going to end. If they're, Lake Balboa, Van Nuys, Chatsworth, somewhere, that's all city of LA. So they can claim COVID not until June 30th. They can claim it until the city changes its law. But for certain judges, they're going to have to come and prove it. So another question is, have we had any success evicting tenants who claim COVID in the city of LA? We've had people where we make deals. Now, you have to understand when you do an eviction, if you've never done one before, we don't like to take these cases to trial. The reason is very simple. Number one, trials are really expensive. And a lot of the time you can get rid of the tenant by paying him less money than it would cost to actually try the case. And you have certainty that the tenant is going to actually leave. Because procedurally, this is what occurs, just for anybody who hasn't done this. Let's say you file an eviction. You come to the trial date, and the first trial date is never the trial date. That's just your first opportunity to settle the case. You come to the trial date, you make a deal with the tenant. That deal is a stipulation for entry of judgment. And the tenant doesn't mind because you're going to keep the case sealed. You're going to agree to that. It doesn't cost you anything, and it's important to the tenant. So the case remains sealed. Your stipulation will contain terms such as when the tenant is moving out, how much he's going to pay you or how much you're going to pay him, how much free rent he gets, if any, what happens to the security deposit. In other words, do you keep it? Do you give it back to him? Are you splitting it? Is it already included in the payout that you're giving him, etc.? And once that stipulation for entry of judgment is signed by everyone, approved by the judge, and the judge will basically read it to the tenant and say, all right, you're okay with this? Do you understand this? Blah, blah, blah. 99% of the time, the tenants will say, yes, okay. And then the judge turns that into a judgment. So the judgment is the first part of a process. Now, let's say it wasn't an agreement, it was a regular default judgment, just so you understand how it works. How do you get the tenant out? You have to take the judgment and ask the court to issue a writ of possession. A writ of possession is a document which is the instruction from the judge to the sheriff to say, please go take this unit or this house back and give possession back to the owner. That's basically all it does, right? Now, the writ, if going back to a settlement situation, the writ will be issued immediately, but it will say there, no lockout prior to X date. And that X date is the day after they have agreed to leave. So if they do not leave by that date, you will have already given all the information to the sheriff, and the sheriff will essentially already be ready to schedule a lockout. So the date comes, the person doesn't leave, they just say, take me out. You just go to the sheriff and say, go ahead, schedule the lockout. And then basically within a week, 2 weeks, sometimes 3 weeks, depends on where you are and which sheriff it is and which office it is, you will get that person out under your stipulation that you already agreed to. So that is essentially how it works with a settlement. Now, obviously, you want that settlement because it gives you certainty. If they don't leave, you could just get rid of them. You don't have to go to trial. You don't have to start the case all over again. You don't have to do any of those things. You have certainty, and it's valuable. Versus if you go to trial, most of the time they will ask for a jury. That jury will be made up of 11 or 12 tenants. And of those 11 or 12 tenants, 11 or 12 do not like their landlord. At best, you're going to have people who are neutral or lukewarm on their landlord. Every now and then you'll have some person who says, oh, I live in this wonderful building. My landlord is my best friend. The manager is such a great person. Yeah, it happens. And every now and then you'll win a jury trial against a tenant who's really doesn't come off as sympathetic. It happens. But most of the time, you're in a situation where especially in LA, judges pro tenant, juries pro tenant, you're paying a lot of money to roll the dice in a situation where the odds are not in your favor. So that's why most of these cases end up in a settlement. Okay, so we have another question. Does the scenario I'm talking about regarding going after back rent apply to commercial tenants as well? Yes, so you can go after commercial tenants for back rent. Oh, I'm sorry. In terms of the small claims, no. This is very important. Thank you for asking that question. You cannot go after commercial tenants in small claims. There's no unlimited cap for that. It's just that's a regular old cap. So if you happen to have a commercial tenant who only owes you up to 5 or up to 10, depending on who you are, yeah, you can go after that in small claims, but it's just a regular case. Commercial landlords got no special dispensation for going after their tenants in small claims cases. Okay, so as he's saying, in the city of LA, if a tenant is subleasing, can we charge additional fees for additional occupancy? If it's rent control, no, not really. The rent freeze in the city of LA is still ongoing. So that basically means on rent control properties in the city of Los Angeles, you cannot raise the rent, period. The only way you can raise the rent is, for example, one of my clients showed me that the city allowed them a $25 or $30 rent increase because they got they got an approval for some retrofit that they did. And so the city literally wrote them a letter, even though it was COVID, and said, you can raise the rent this much for these units, right? And so when the city permits you to do that, then you can raise the rent. And the moratorium even specifically provides for that little bit of an exception. Unless approved by the city, you cannot raise the rent on rent control units. So any increase in rent is subject to that rent freeze. That would include the rent increase for additional occupants that is, COVID notwithstanding, otherwise permitted, but not right now. Okay. Do we have any more questions? Please feel free. There's no bad questions. I'm sure whatever you want to ask, someone else already has on their mind, so it would be helpful. So another question, can you charge NSF fees? NSF fees, yes. Not late fees, but NSF fees, yes. Maintenance fees, if you're talking about the SCEP fees, yes, you're allowed to charge SCEP fees. If you're talking about something that's not, because you're saying Santa Monica and West Hollywood, Ezzy, I think you're not talking about SCEP fees. So when you say maintenance fees, can you help me out and tell me what you mean there? And once you let me know, we'll come back to that question. Gino's question is, so there's 3 different periods of past due rent: pre-September 30th, October to March, and April to now, all of which will have different notices for each period. Yes, that is correct. So pre-September 30th are 15-day notices. October 1 are 3-day notices with some extra language. April 1 now is basically regular 3-day notices. So going back to Ezzy's question, maintenance is a tenant causes a sink or toilet backup. Yeah. If they're doing something that is causing you damage and under lease, you're allowed to charge them for it. Yes, you can take it out of their deposit and then basically say, now you have to replenish the deposit, or you can charge it to them, because that's not a late fee. That's just a violation of the lease. And so if they don't pay it, you can send them a cure or quit. That's not a pay or quit, because it's not rent. It's a cure or quit. So Benko is saying no rents can be raised in LA until when? So just want to clarify, because that's not 100% accurate. The rent freeze in the city of Los Angeles only applies to rent control properties. So if you have single family homes, you can raise the rent all day long, right? And if you have properties that are not subject to rent control, otherwise, you can raise the rent. Now, some of your properties, if you're multifamily in the city of LA, might be subject to AB 1482, and in that case, you would have the increases that are there limited. Right now, it's 8.6%. We are expecting the CPI numbers for April to come in May. Basically, I think everyone knows that there's huge inflation going on. We are expecting the CPI number for the LA Southern California region to be even higher than 5%. So that means with the base 5 plus the CPI of more than 5, we're going to hit that 10% cap. And I think starting in May, your AB 1482 building rent increase is probably going to be able to go up to 10%. I don't know that for sure. The CPI numbers have to come out. Might come out to 4.9. I really don't know, but it's unlikely. So Benko, basically, if it's not rent control, you can raise it to whatever you would otherwise be able to raise it to. If it is rent control, 0. Until when? We don't know. The city of LA hasn't indicated when they're going to change that. So Carmine, you cannot charge late fees in LA, period. No late fees in the city of LA. Doesn't matter if it's rent control or not. Now, again, if you put the late fees on their ledger and they pay it, okay, no problem. If you, they may come after you afterwards and say, hey, give me back my late fees if they figure it out. But there's nothing necessarily, it kind of is, but if you ask them for a late fee innocently and they pay it to you and then they never figure it out, essentially no harm, no foul. If they do figure it out, you might have to pay them back the late fee. Next question. In the city of LA and Santa Monica, we push for eviction for pets and smoking. Okay. Pets are really hard. Pets are hard because anybody can get an ESA letter. That's an emotional support animal letter from any psychologist. They're, as easy to get as the prescriptions for marijuana were before it became recreationally legal. And as soon as they give you an ESA letter, you really can't evict them for having the pet, even if their lease says absolutely no pets. Now, there are limitations to that. They cannot have a, pet venomous snake. Theoretically, I guess they could if they were taking care of it. But I guess a better example would be no pet crocodiles, no pet pigs, no pet bears, no dangerous animals, actually. And even if they have a pet, pit bull that is aggressive and has bit people, we don't care if it's an ESA, they can't have it there. So, but other than those circumstances, generally speaking, if they got a pet and they have an ESA letter, you're not going to be able to evict them. Now, if they don't bring the if they don't bring the ESA letter and they have a pet and your lease says they don't, then yeah, you can go ahead and evict them for it. Now, in Santa Monica, in the city of LA, they might be able to say that the pet was because of COVID somehow, that the pet was someone else's pet that got kicked out of their unit. They have that extra defense. But really, the ESA defense is 10 times easier and stops you in your tracks. So is Ellis prohibited? In the county of LA and in the city of LA, yes. Both in the city and the county, there are no-fault evictions permitted right now. So you can't do an Ellis. In the city of LA, you can't do any. In the county of LA, there are certain restrictions on doing landlord or landlord family evictions. They're quite stringent. You need to be an individual owner. You need to want to be able to move there, or the person who needs to want to move there has to be there for 3 months. You have to give the 60-day notice. It's a whole Megillah, as we call it. If you happen to be in one of the situations where you're outside of the city but inside the county and you want to do a landlord occupancy or landlord family occupancy eviction, give us a call and we'll tell you if you qualify. But it's a lot of hoops to jump through. But generally speaking, yeah, Ellis is prohibited for anywhere in the county of LA. So we're asking a question about late fees outside of the city, inside the county. Not really. No, you can't really do late fees in LA County. City of LA, owner move-ins resume on June 30th. No, not as far as I know. The city doesn't really have a timeline that I'm aware of that says when they're going to have no-fault evictions again. Basically, their moratorium says that there's no-fault evictions until the end of the emergency period plus 60 days thereafter. So June 30th is very unlikely unless they declare an end to the entire emergency on April 30th, which, as far as I know, they won't. Owners, okay, so another question is, owners can evict if they want to sell until when? Again, in the city of LA, you can't do that. In the county, there are certain ways to actually, wait, no. If you want to sell, no, it's not. It's not if you want to sell. It's not if you want to sell. It's if you want to do a move-in, and then the landlord, when he buys, he can do it. Most of the time, you have to do that in terms of a cash for keys. By the way, cash for keys works for everything. If you want to take a unit, cash for keys is really the way to go nowadays, and we can help you with those as well. So Gino was saying, is that county of LA maybe? June 30th. Not really, because again, that's a no-fault eviction, and the no-fault evictions are pretty much still not allowed until December 31. But if you have a situation like that, just give us a call and we'll see if we can work it out. So Jeff is asking, all of our rents are $25 more, i.e. rent is $1,025 on the lease, but we offer a $25 discount for on-time rent. Comment. Okay. So you're asking, is that a legal or illegal late fee? So in other words, if they pay you on the 1st, it's $1,000. But if they pay you after the 5th, the rent becomes $1,025. I think an LA judge will tell you that's just a roundabout way of charging a late fee. It could be considered a concession. That's potentially, but because the concession is essentially predicated on the timely payment of rent, it still sounds like a late fee. So certainly in a rent control property, in a city of LA rent control property, city of LA judge isn't going to let you get away with that. I think out in San Bernardino, Riverside, you're probably okay, because again, you can charge late fees there. No one cares. But in the city and the county, I think you might have some problems there. Again, I wouldn't do an eviction on someone failing to pay you $25. It's not going to go anywhere. Plus, once you do the 3-day notice, they'll just pay you the $25. You might be collecting an illegal late fee, et cetera, but theoretically speaking, is it legal? Probably not. But because you've structured it as a concession, there's no real definitive answer. Okay, next question is, can short-term rentals like Airbnb be evicted? Absolutely. An Airbnb is a tenancy like any other. So it doesn't matter if you are renting a house for a day, a week, 2 weeks, a month, or a year. If you violate the terms or if you fail to pay the agreed upon rent, you can be evicted. And we've had to do Airbnb evictions a number of times, or VRBO or anything like that. So, any more questions? So Jeff says lease also includes a 25 jars serving a 3-day. That's probably okay. But again, by the time you're actually done serving the 3-day, chances are they're already not paying. So you would have to do that. You would have to add that to the 3-day cure quit. Again, it's a smaller fee. If that were the only issue that happened, it probably wouldn't be a very good eviction. Like theoretically, legally, is it good? Yes. Practically, will a judge let you evict someone for not paying $25? Probably not. You're just going to say it's not material. They'll find a way to reject your eviction. Airbnb in LA cannot be evicted until June 30th. Again, so the Airbnb is treated the exact same as any other tenancy. It doesn't matter whether they got into the property through Airbnb or a standard lease or whatever it is. If they didn't pay the rent, they are subject to eviction. If they're in the city of LA, they have the same defenses. If they're in the county, they may or may not have the same defenses depending on whether we're before June 30th or after July, if they're low income or not. Airbnb, in terms of landlord-tenant laws, are not really treated any differently than a regular old tenant. So they could theoretically, yes, have COVID-related excuses. So if a tenant got funded for unpaid rent in 21, but is not paid after that period, he hasn't paid since April. So yeah, I think we covered that a little earlier. But yes, you can go ahead and start the eviction. Again, caveat for where they are, they may have a COVID defense. But yes, you can start the eviction. Any more questions? Yeah, Maurice, just unmute yourself.
This is not a question regarding rent, collection of rent or anything like that, but
okay.
This is regarding 21-day and dispositions and stuff. You know, I years ago, probably like 10, 15 years ago or something like that, I remember going to court one time, and you know, you always get those tenants that I try to get my dispositions out like in 15 days, no longer than 20 days or 18, whatever. I mailed one out 18 days. He got it like 22 on the 22nd day or something like that. And I know that when I went to court one time, the judge told me, he says, you know, you don't actually have to have the disposition in the tenant's hand within 21 days. You're given like 5 days for mailing.
Correct.
What is that the legitimate, timeline?
Yep. You just have to put it in the mail by the 21st.
Okay, put it in the mail. Okay. Yeah, they're always confused. They always tell me, oh yeah, you didn't give me 21 days, and now you have to give me twice my deposit. I'm like, no, that's not how it works.
No. Okay.
Yeah.
Also, take into account that what you're talking about is called treble damages. And by the way, it's not 2 times, it's 3 times. Because the way the law works is that if you don't give them back the deposit, then you could be subject to treble damages of twice the deposit. Well, twice the deposit is twice, plus there's still the deposit. That's 3 times.
Oh, really?
Yeah.
Okay.
However, that is only for what's called a bad faith retention of the deposit.
Exactly. Yeah.
Right? So if you just made a mistake, right, or if you have a good faith dispute with the guy, right, then you may very well have a good faith reason for not having given him the deposit. You may even end up losing that debate. You say it cost me $2,000 to repaint your apartment, and you really paid that much. You have an invoice from the painter, right? The guy comes to small claims and says $2,000 to paint a 1-bedroom apartment is ridiculous. Here's 5 invoices from 5 different licensed painters who will paint it for $500. And the judge says, yeah, you're right. Maurice, sorry, you got ripped off, but really $500 was the reasonable sum. The security deposit was $2,000. You have to give him back $1,500. You had a good faith reason. That's not a bad faith retention. So it is very unlikely that the judge would award treble damages in that kind of a situation. Bad faith means you know full well you're supposed to give back the deposit, you're just choosing not to. Or you're making up nonsense in the letter that you didn't really spend and that you didn't really do. Right? That can also be bad faith retention.
Sure. What about situation? What about have you had any issues come up with like pre-move out inspections? You know, I get this once in a while. You know, we'll send out the pre-move out election form and stuff, and we won't get it back. And all of a sudden, you know, somebody will call me on the 11th in a half hour. You know, hey, you know, I'm moving out. Can you come do my pre-move out inspection? I'm like, I'm out of town. There's no way in hell I can do this. What has been your experience on that situation? I mean,
everyone essentially is obligated to be somewhat reasonable under the code. They can't tell you, hey, I'm moving out today. Come do my move out inspection right now.
Yeah.
And if you don't do it right now, then you missed your chance. That's not going to work, right? If you're telling them they have the opportunity to do it and then they never schedule it with you, they've essentially waived their opportunity, right? So the way it goes is you have to tell them they have an opportunity. First, they have to tell you they're moving out.
Yeah.
Right? Technically speaking, that has to be 30 days notice. So if they call you up the day they're moving and say, by the way, I'm moving today, and then they move out, they didn't even give you a chance to give them the notice.
Yeah.
Right? They prevented you from complying with the statute. And if you can prove all of that, I think that would be a defense to them saying you didn't give me an opportunity to do the inspection. They moved before you could even do it.
Yeah, you know, I had a weird situation come up where the guy, they call me 11th hour and says, hey, you know what, I'm not going to be, you know, I completely forgot about this notice. Can you come do a pre-move out? I'm like, no way, no, I'm out of town. I'm an hour away, you know. Right. And I said, what I'll do is I went anyway. I drove home, or I drove to the property after I was done with work. Did a kind of an inspection, email it to him and said, this is what we're looking at. And I said, if you want to come back and correct some of these issues, you know, you're going to have to pay additional rent. I'll let you into the property, you know, I'll give you like 24, 48 hours and then that's it. And just because I knew the kind of tenant they were. And so they didn't respond at all. And then, when I gave him disposition, he saw that I took all his deposit because of course he destroyed the place.
Right.
And then now he's, you know, threatening me and saying, hey, yeah, you went over 21 days and you were unjustified in some of these things. And I called you the 11th hour and I said, hey, you never gave me a possession of the property. And so he was supposed to turn in the keys on Friday. He called me like over the weekend or something like that, or Monday. He said, hey, listen, you just rekey and I'm not going to turn in your keys. I'm like, well, I don't have possession, so I'm going to charge you from the time I received the call from you.
Right.
You know? And so that's what I did. So I did my proration and everything based on that. And so, so that was the kind of a weird situation, but.
Sure. Did he sue you?
No, he keeps on threatening to sue me, you know, but I mean, he hasn't sued me yet. So, I mean,
I wouldn't worry about it.
Yeah, I'm well documented, so I'm not
okay,
too crazy about it. Yeah.
All right. So, gonna do some more questions here.
Yeah.
So, Benko is asking, is there a $600 penalty for not returning the deposit other than bad faith retention? No, not really. The penalty is the treble damages, up to 2 more times for bad faith retention. Oh, in LA, I don't think so, but I could double check the LA regulations for that. Generally speaking, people are going after the big score of the treble damages. So speaking of deposits, if a tenant doesn't want to give forwarding address, it's our responsibility to send the deposit to the last known address. I mean, you send it to the address at the property to show you sent it and hope it gets forwarded. If it doesn't, at least you have the return envelope. Yep. And if you don't send it, that's a bad faith retention. I wouldn't say it's a bad faith retention if you don't send it, but if you don't send it, then you may get hit up for not sending it, and you may get a little bit of a penalty, or it just depends. Generally speaking, yes, you mail it to the last known address. If you know for a fact you're sending it to an address they don't live in anymore, you're just following the law. If the law is written badly, it's not your fault. If they don't give you a forwarding address, that's their problem. And if they're expecting the postal service to come and take care of it, again, that's their issue. If it doesn't get to them, not your problem. What's the law on commercial security deposits? Commercial security deposits generally follow whatever the lease says. So if your lease has a provision for how commercial deposits go, then that's what you follow. If not, then there's a whole different provision for commercial deposits in the code. Ezzy, you know us, you can call us, and we'll go over it with you, because it's a little different, but I mean, basically the same idea. But we'll go through the details together. So, any other questions? As we're about hitting the 1 hour mark. Anybody else?
I got one more question for you.
Sure.
It should be a quick one. On this same situation, the tenant moves into this property. The owner puts in these custom honeycomb window coverings that, they retract from coming down from the ceiling and going up and everything. Anyway, they were really expensive. So the tenant, I guess, ruined them and decided he was going to put up shades. So he ripped everything down, put up shades, and then I charged it for these window coverings. And he's saying, "Well, no, that was part of normal wear and tear." I'm like, "Well, no, it wasn't, because you didn't even leave them there for me to determine what kind of shape they were in. You just decided on your own to just discard them."
Right.
So I charged it for replacing, the custom window blinds.
That's reasonable.
Yeah.
That's reasonable. Sure. Yeah. That's not normal wear and tear. Normal wear and tear is you use the apartment in the normal way you do it. So, for example, if you have someone who's been living in their unit for 25 years and the carpet's just all messed up, that's probably normal wear and tear. If it looks like it's been 25 years and it's only been 1 year, that's not normal wear and tear.
Yeah, exactly.
That's pretty much how it works.
Yeah, like I said, he didn't even give us the opportunity to determine what kind of shape they were in. He just decided on his own to discard them.
Yeah. Yeah. No, I mean, that's like if you take off light fixtures, or throw away refrigerators. That's not normal wear and tear.
Yeah. Hey, he also did that. He threw away washer and dryer that he said they were broken. Well, you needed to help let us determine that.
Exactly. Yeah. Exactly.
All right. Thank you.
Okay. Yeah, no problem. So, any more questions? Feel free. So Ben goes saying, rent control in LA, why doesn't the landlord have to replace carpet that's totally aged out and dirty? Why doesn't the landlord have to? Depending on how bad the carpet is, I mean, at least in West Hollywood, you have to. In LA, it's not necessarily specific, but if it makes it uninhabitable, in other words, they have a floor that's just so bad that it's, disgusting and dirty, you may have an inspector that says the carpet needs to be replaced. It really depends on how bad it is. She's asking because she's on Social Security. I don't think that really has much of a difference. The inspector told you no, but it is filthy. If the inspector told you no, then you don't have to fix it. I mean, carpets can be filthy. I mean, the way you fix that is by just, vacuuming it and shampooing it. If you want to do it, great. If the inspector told you don't have to, then don't. You felt badly because she's been there for 13 years, then do it. Great. If she wants you to and you want to, then go ahead and do it. You're allowed to do more than what the law requires. You know, if you want to go into everyone's units and put Viking stoves in there, go ahead. No one's gonna stop you. Well, it's a crazy tenants, Mike. But the landlord won't give you permission. So Benko, I'm a little confused. I thought you were the landlord or are you a property manager? You manage. Okay, so if you're a property manager, what your owner says goes. So you tell the owner, hey, we have filthy carpets. The inspector is telling us we don't have to. We think it might be a good idea to do it. It's up to the landlord. At the end of the day, it's not your property. So if he doesn't want to do it, unless you guys want to, actually, even if you do want to come out of pocket, if he's specifically telling you not to, I would regard it as your fiduciary duty not to do that. Follow what he says. Because he's not asking you to do anything illegal. She never missed a payment. There's that exception to every rule. That's what housing is there to do. Housing is, if you are violating the rules and the tenant feels that the home is uninhabitable, they have the option of calling the housing department. And if the housing department comes out and inspects and doesn't issue you a notice in order to comply, it means they have made an administrative decision that there is nothing about that carpet which makes the apartment uninhabitable. So again, if you want to have that debate with your owner and say, we think that it would be a good thing to do, or moral or ethical, or it would be good for the morale of the tenants in the building, or we're afraid that she's going to tell all the other tenants in the building that we're not good landlords or we're not good managers, and then they're going to report it on Yelp, whatever it is. You can use whatever arguments you want if you really feel strongly about it. But at the end of the day, if the inspector doesn't tell you to, and there's nothing in the law which says you have to, and believe me, if there was, the inspector would definitely tell you to. They are not shy. A lot of the time they go over what's required. But yeah, if you just think it's proper, I wouldn't disagree with you. But again, it's not my building. If it were my building, I would tell you to do it, but it's not. All right. So thank you everyone for joining today. I hope it was educational. I hope it was informative. I hope everyone is having a decent time, navigating all of this stuff. I think now that we've gotten into the April time period, that a lot of the COVID stuff, at least for a lot of people, is really starting to taper off, which I'm really happy about. And hopefully we'll get to completely full 100%, normal or back to normal as soon as possible. So thanks everyone. Oh, thank you for the happy belated Passover. Thank you for everyone, all your comments. Happy belated Passover and belated Easter to everybody. So we'll catch you next time. We'll try and do this again in May, but if there's no changes, then maybe in June. So look out for the next one in your emails. Thanks, everyone.
Thank you for your time.
No problem. But anyway, if you want, davidovichlaw.com, DAVIDOVICHLAW.com. Bye, everybody.